This is Professor Daniel Erasmus, just to give you an update on administrative and constitutional law, where from time to time I find cases that are analogous to tax situations. The case I'd like to briefly discuss today is Ulde, U-L-D-E, versus Minister of Home Affairs, 2009, Volume 4, Essay, page 522, and it's a Supreme Court of Appeal case. Now, the case surrounded an issue of the right to freedom in respect of a person who had been deported by the Department of Home Affairs. And in this particular case, the Supreme Court of Appeal declared that Ulde's detention at a detention center on 6 February 2008 had been invalid and was set aside. The court held that the immigration officer had failed to exercise any discretion or had not properly exercised his discretion in deciding to detain this particular individual. It accordingly set aside a judgment of the Johannesburg High Court dismissing the application to declare Ulde's detention unlawful. Now, by the time the appeal was heard, this particular individual had already been deported to India. Now, what is important from this particular judgment really comes out at paragraph 10 of the judgment, where it was submitted an argument that Ulde's detention was unlawful because it was carried out pursuant to a blanket policy to detain all persons found to be illegal foreigners. There is merit in this submission, the Supreme Court of Appeal held. It is clear from the extract from the official's affidavit quoted that he believed that he had an obligation to detain Ulde when regard was had to the appropriate provisions of the Immigration Act. Now, the section in question of the Immigration Act, Section 32, imposes an obligation on an immigration officer to deport an illegal foreigner. It is not concerned with the power to detain that person. But assuming that he had an obligation to detain the appellant, the official was not exercising any discretion. He was carrying out what he believed to be a blanket policy, which by definition precludes the exercise of a discretion. Now, the relevance of this to matters of taxation is that, of course, SARS is often given discretions, particularly when it comes to issues such as auditing a taxpayer, or for instance having a search and seizure warrant issued, or let's say for instance exercising a discretion to investigate the affairs of a particular taxpayer. And sometimes these particular decisions that they take might be driven by blanket policies. And in this regard, this particular case is authority that a blanket policy that might be handed down from the Commissioner to all the SARS officers would not be the proper exercise of a discretion. A discretion must still be properly considered and exercised before any of these powers are in fact exercised by those officials. I trust that you'll find this useful in looking into the discretions of SARS. That is all for today. Until next time, goodbye.